Welcome to the Minnesota Law Review Symposium, A Hill to Die On Federal Reform in the 2020s. I'm Daniel Suter, the Symposium editor for Volume 106. This panel is a discussion of potential reforms to the United States Supreme Court. Over the past decade, conflict over our country's high court has become a major topic of both the political and cultural mainstream. This week alone saw the confirmation hearings for Judge Ketanji Brown Jackson descend into red meat political theater, while questions about both Justice Clarence Thomas's health and discretion over conflicts of interest continue to circulate. Today we ask, what do we do about the Supreme Court? Our panelists today are Leigh Coleman, Executive Director of the People's Parity Project, Professor Tarlee Grove of the University of Alabama Law School, and the Professor Daniel Epps of the Washington University in St. Louis School of Law. Now I'll turn it over to our moderator, Professor David Schultz.
Great. Thank you very much to all the participants today. And thank you very much to all the audience, which is going to be here for today. And what I'd like to do is start off and just talk about a recent poll that was done by Gallup, and then turn a couple of questions over to all of our panelists in terms of reacting to it. And some of you may have seen this poll that came out last fall. It was a Gallup poll which pointed out that the trust, or rather the approval rating for the U.S. Supreme Court was now 40%, with a disapproval of 53%. And what had happened, when you read the article, if we go back over a 20-year period, 25-year period, go back to, let's say, August of 2000, the approval rating for the Supreme Court was 62%, disapproval 29%. And we've seen a slow, steady erosion in terms of public approval for the Supreme Court. Other polls have also indicated declining trust. And this is important because while for a long time, approval ratings for Congress or for the president have been well below, oftentimes 50%. This is now a trend that is unusual for the Supreme Court, where the public seems less likely and less supportive of the court than it has been in a long time. And so I'm going to throw this out to all the panelists, and maybe we'll start, I don't know, perhaps maybe with Professor Grove, and then Leigh Coleman, and then Professor Epps, in terms of saying, should we be surprised, or should we be worried about the fact that there's these declining trust and approval for the court? And then with that, why? What's going on here? Why is it now becoming maybe not the least dangerous branch, but becoming a less favored branch or trusted branch than it used to be? So I don't know, Professor Grove, would you like to sort of take a few minutes and maybe sort of talk about that, or where would you like to go?
Right. So I think, of course, one should be concerned if any institution of government seems to be losing some respect among members of the public. All institutions need legitimacy. That is what some of us call sociological legitimacy, the general support of the public to function. Courts particularly need sociological legitimacy, the support of the public to function. And so one should be concerned. I appreciate the fact that you recognized it hasn't been a single trajectory. Over the last couple of decades, all institutions of government have gone down in terms of their public esteem. The Supreme Court far less than Congress or the presidency, and the presidency less than Congress. But yet it hasn't been just one slow downslide. As you pointed out, in August of 2020, the Supreme Court's approval rating was around 58%. And this was the highest it had been since 2009. Probably not coincidentally, soon after the Supreme Court had issued decisions in Bostock versus Clayton County, where it held that Title VII protects the rights of gay, lesbian, and transgender individuals. This was very soon after the Supreme Court had ruled in the deferred action for childhood arrivals case, the census case, and it issued some decisions that would have been quite surprising to many people on the left. It hit a low in September of 2021, perhaps not coincidentally, soon after the Supreme Court declined to intervene in Texas's SB 8 abortion law. So there are lots of things surrounding the Supreme Court that can either make its approval go up or down, but certainly it should be concerned, or we should be concerned about it. Now, what to do and what are the causes, I think, are something we should probably discuss. I think it may have a lot to do not only with the Supreme Court's jurisprudence, but also with the confirmation process. As we have seen, it gets quite ugly, and that influences the public's perceptions of the court. So I want to stop there and let my co-panelists talk, because I think we could go on for quite some time about both the causes of the legitimacy crisis and what should be done about it.
Okay, good. Ms. Coleman?
Yeah. First of all, hi, everybody. Really excited to be here. Thanks everybody who pulled this together. Pulling together a conference during Zoom and COVID just sounds hellish, so appreciate it. I echo a lot of what Professor Grove said. Government needs legitimacy in order to function. The judiciary in particular requires legitimacy in order to be able to do its job as a branch of our government. I think when I think about the declining public satisfaction, public approval of the Supreme Court, of the judiciary more broadly, I do think that there are some reasons to find optimism. One thing that I think about is the need for democratic engagement with the court as a whole, with the Supreme Court. We need people to be paying attention to what's happening. We need people to be paying attention to how the confirmation processes are going, how they're functioning, whether they're happening at all. Thinking obviously about Merrick Garland's lack of a confirmation hearing entirely. From my vantage point, there are very, very real reasons to question the legitimacy of the Supreme Court, to question how these justices came to be on the bench, who's on the bench, who has appointed, who has confirmed these justices to the bench. That calls the legitimacy of the court into question. And the people in this country, voters, the populace, should be engaged with these questions, should be thinking about it. And kind of in my line of work, organizing around the judiciary, organizing around the court, a major obstacle to doing this work is that folks are told, starting in elementary school, high school, kind of your basic civics 101, what I consider to be many myths about the role of the judiciary, about who makes up the court, about how they operate, about their ability to be separate from politics, from kind of the general mood of the country. And to me, when I see numbers like we've seen recently with kind of decline in public trust in the court, that suggests that people are starting to question what's happening, question what's being taught, thinking a little bit more critically about what's actually happening within the judiciary. And that suggests to me that folks are engaging with this branch of government, which I consider on the whole a good thing. I wish that they were able to engage with the judiciary and come away thinking that it was a legitimate branch of government, that this court was legitimate. But I think that we need to do work, kind of the government needs to do work to get the court to earn that legitimacy once again, before we'll start to see that public opinion change. So I think that there are many reasons for concern, but I do think that there's some cause from my perspective for optimism with the critical engagement with the judiciary that those numbers suggest.
Okay, good. Professor Epps?
So yeah, it's a really interesting observation to start with. And, I would, obviously suggest some caution before jumping to big conclusions, because these things do swing. And there's been moments in the past where people have sort of seen legitimacy crises coming, and then it tilts in the other direction. But there may be some reasons to think that this is something more serious. One being that, over the last few decades, you've had a court that, I think you could describe it in many ways as kind of a conservative court, but it's also a court that has issued decisions that kind of provide victories to kind of different sides of the country in different kinds of cases. And maybe that, produces a certain amount of support for the court. And there's reasons to think the court has become more partisan, that the decisions are more closely tracking partisan affiliation across the board. And I think if that continues to be true, it's hard to imagine that people won't just see the court as a partisan institution, and that will produce kind of less respect for the court. Whether this is a thing we should be worried about, I think probably yes, although I want to clarify that my thinking on that, which is that my concern that I've written about, some of my work with Ganesh Siddharaman, is to the extent you see the Supreme Court being suffering a loss of legitimacy, it could produce sort of less respect for law generally and for the rule of law. And I think that's a very scary place to be. If we start seeing law generally across the board being seen as purely a partisan institution rather than a set of rules that binds people and government across the board, that strikes me as sort of something that would put us on a downslope towards a form of government that I think we'd really be troubled by. On the other hand, if it doesn't have that bigger picture effect, how you feel about it might depend a little bit on how you feel about courts. And a Supreme Court that has a little bit less legitimacy is maybe one that has less power to overturn legislation and is a little bit less able to get out in front of the country. And you might think that's a good thing, depending on whether you'd rather have more decisions being made by the political branch rather than by the courts.
Good. All right. Let me do a follow-up question here. I'm both a political science professor, PhD political science, and a law degree. I live in two different worlds. So I live in empirical political science, and I live, in law school. Okay. When I talk to my my political science people, they oftentimes will say to me, "Let's just face it, Professor. The court is a political institution. What a person." They're appointed by what? By a person elected to office. They're confirmed by people who are elected to office. Let's just face the fact that what? They're just a political group of people, and that we've been living with this fiction for years, that they somehow are not politicians with robes. So this is sort of following up a little bit on something that Ms. Coleman was making here. I'm thinking about here. Should we just recognize and just say, guess what? At the end of the day, the court is a political body. It's a political institution. These are political actors, and get over it. And then maybe rethink how we think about the court based upon that. How would you react to that? Let's just be realistic. Molly, Ms. Coleman, can I pick on you with that?
Definitely. And as the non-law professor on this panel, I'll get my probably unpopular opinion out of the way first, and then we can go to the law professors. Yeah, to be honest, I think law school didn't really stick in my brain and something didn't click. I'm very much of that mentality, right? I think that there is nothing that I have seen in my short legal career to suggest that the court is not a political body. Of course, that doesn't mean that I think that the Supreme Court should be, elected by popular vote, and that we should abandon the project of a judiciary altogether. Absolutely not. And I think that the common counter arguments to this would be things like, well, look at how often the Supreme Court is actually reaching decisions on a 9-0 basis, or where the ideological predispositions of the justices is not necessarily seeming to shape the outcomes. And I think that's absolutely true. And there's a reason why on many cases the law is clear, and justices aren't able to simply impose their policy preferences. And that is important. And there's no reason to abandon a body that can do that and that play that very important role. That said, when it comes to the most high profile political decisions, we see time and time again that the justices' votes are going to be determined by the party of the president who appointed them. And that's not a coincidence. That's not because some people, utilize different methods for interpreting the Constitution. It's because people have different political preferences, and they are imposing those preferences on the case in front of them. Where that leaves us, I think, is a very important question. And I think that is, potentially the question of the panel is, what do we do with that? But I think to deny the reality, again, exactly as the question was posed, I think it's the reality that this is a political body. These are political figures who are tasked with doing their job in a certain way and are often very good at that and occasionally able to put aside their political priors. But we all can see what's happening. There's a reason why we know how the vast majority of the justices are going to vote in Dobbs. There's a reason that we know how they are going to vote in almost all of the high salience political cases. There's a reason why we know how they're going to vote when it comes to voting rights cases and questions about democracy. Again, just because that doesn't happen 100% of the time, to me, that's not a persuasive argument against this as a political body. And I think we should treat it as such.
Yeah. Let me make one more point here, and then both the other professors, please do chime in here. I was going to say is that I think it was the Minnesota Law Review about a decade ago that actually published an empirical piece that basically made the point that you were making here, which is that just about the best predictor of about how justices are going to vote is look at the appointing president. And so making that point there, and just think about how the media reports on the court now. They say liberals versus conservatives or Democrats versus Republicans. It's almost like the veneer has been stripped away in some sense. Professors Grove and Epps, thoughts?
So it's a really, really hard question, and it's hard because I think the answer is it's complicated, which is that the two perspectives that you have, the law and political science, I think are both really, really important. And it clearly is true that ideology of appointing president explains, or at least correlates with a really large number of the decisions, especially the ones where we care about, but also there's a bunch of places where that's not true. And I think it goes to the fact that the court is really kind of two courts. It's an institution that solves a lot of, kind of technical legal questions about, obscure provisions of the ERISA statute governing employee retirement accounts. And it's also a constitutional court that decides these big questions of high principle about whether there should be, a right to abortion, what does free speech mean. And, I think it's kind of important to disentangle the two things. I think the first set of cases, are not that ideological and they're technical and turn a lot about legal considerations. And the other set of cases, seem to track politics more. The reasons that they do is, somewhat complicated, and that, presidents understand the different judicial ideologies and they can select justices whose ideologies and judicial philosophies track partisan ideology more. But it's unclear what to do with that observation, because the more we embrace it, the more it becomes a self-fulfilling prophecy, and where we're just sort of saying, well, they're not doing law, this is pure politics, and that's what we should expect them to do. On the other hand, the more we resist it, the more you maybe are putting a veneer on decisions that are hard to explain as something other than partisan. And so I think it's something that I struggle with how to think about, and struggle with how to teach students about, how to talk about in public. And I haven't reached a happy resolution on that.
Okay, Professor Grove.
Right, so I think I agree with a lot of the things that have been said already. I think when one says, is the court a political institution, it's hard to know exactly what that means. Well, of course, the Supreme Court is created by a political process. The president nominates justices. They are confirmed with the advice and consent of the Senate, and that's naturally going to be a political process. And yet, the Constitution also contemplates a good deal of judicial independence. That is why they are given salary protections and tenure during good behavior. So we have this assumption that there's going to be some independence once they go through that political process and get on the bench. Add to the complication what both Dan and Molly were indicating. Well, we've got lots of cases that just don't really turn on ideology at all. And then only a small subset that seem to involve ideology for many people. I do think it's important to note, those are the cases that tend to impact the public's perception. It's that subset rather than the overall cases. Much to my chagrin, people don't focus on the jurisdictional niceties that I like to think about a lot. So I think that subset of cases is really important. I do think it is valuable that the justices do not conceive of their role, and I do believe that they do not conceive of their role in partisan terms. And that is in part because of the schoolhouse story that Molly was referring to, and that Dan referred to as well. It is our conception of the judges that actually put some constraints on them. It is the obligation of the judges to give reasons for their decisions. They can't just say, boy, President Obama would love this, or President Trump would love this, and so that's what I'm going to do. No, they actually have to provide reasons. And I think that puts a lot of constraints on judges that makes the law matter, even in those hot button cases that seem so ideologically driven.
I think you're absolutely right. There's a sense in which, I mean, there's this body of decisions that go, or actually I say literature that goes back, I'm going to say to the 1950s, that says that courts are different than legislative bodies because they're supposed to make, as you said here, decisions based upon principle. We've got people such as Robert Bork and a whole bunch of others who wrote, landmark pieces, 40, 50, 60 years ago that made that distinction. But I'm going to play devil's advocate just for a second here. Is that one of the things that my Senator Amy Klobuchar in Minnesota was talking about the last couple of days was the fact that increasingly the court is using what's called the shadow docket, a way of deciding cases. And think about just this week, the decision that the Supreme Court issued regarding vacating the lines that are being drawn for redistricting in Wisconsin. So just playing this out here for devil's advocate again, is that, so I guess 2 points here. One is, how do we get the court back into that schoolhouse image, put them back there. And doesn't this emergence of what we're talking about, the shadow doctrine, or shadow docket, not doctrine, I'm sorry, shadow docket, doesn't this raise new troubling questions? Because it does look like now the judges are just saying, do this or do that without giving explanation.
So I'll go ahead and start. I actually don't think these are entirely new questions. The Supreme Court used to have mandatory appellate jurisdiction and had to give reasons in every case that it heard. It had a much smaller docket back in the early to mid 19th century that grew dramatically in the late 19th and early 20th century. And it was since the Supreme Court has had discretionary jurisdiction since 1891 to some degree, 1925 to a larger degree, 1988 to a huge degree, that the Supreme Court has issued so many reasonless decisions. And even in the decades leading up to 1988, the Supreme Court did things like summary affirmances or rejecting a case for not presenting a substantial federal question. And these turned out to be one-line orders that actually were supposed to be precedential and told lower courts next to nothing. So I think what we're seeing today is actually more attention to a problem that has existed for a couple of decades. And I'm actually glad that there is this kind of attention to the court's emergency docket, because I think that's needed, because that can pressure the justices to potentially put more things on the regular docket and give reasons, which it has done in some cases. I don't think enough cases. But I think the attention is warranted. It has been for quite some time.
And in terms of the shadow docket, I think it's important to try to disentangle the particular things that people may or may not find troubling about that. And I think that it's maybe unfortunate that some of those various criticisms have gotten lumped together under that heading of the shadow docket, which I think is a good starting place. But the court sometimes has to do things on a quicker timeline. Sometimes those decisions come with explanations, sometimes they don't. It seems like there's actually been a greater effort by the court to provide explanations for things that it's doing kind of on the emergency docket, and maybe that addresses some of the concerns we might have about them moving quickly. And so I think that rather than just the common criticism saying, well, they're doing a bunch of things on the shadow docket that's troubling, I think we need to figure out exactly what we might think is troubling about that, and whether those specific objections apply to the specific things they're doing in specific areas.
Okay, good. Ms. Coleman?
Yeah, I would add, so I have many concerns about the shadow docket. I think, to Professor Epps' point, disentangling those has value. I think, though, from, in terms of are the justices making decisions outside of the standard process that are affecting large numbers of people without adequate briefing, without adequate explanation to the American public? And is that making people's lives meaningfully worse? I think the answer is, it's yes. We know that that is happening. We know that it's happening in increasing number. And I think that that is incredibly alarming. And to the original question, if there are unique or important ways in which the court is distinct from the political branch, the other political branches, if they're not doing their job in the normal way or in the way that we want them to, or that we're taught that they're doing, then that raises concerns if it's impacting people's lives. I think the other piece of this, right, is that, as we've talked about already today, this notion that, the process is intended to exist with judges who are separate from, they are not supposed to be members of the Republican National Committee who then go straight to the Supreme Court. They're supposed to be this true, meaningful separation from partisan politics. I think part of what's leading to this lack of legitimacy, part of what leads to this concern about kind of what the court is actually doing, is that the reality is that we know that that doesn't happen, right? We know that Supreme Court justices are going to Federalist Society events and that they are hobnobbing with the very folks who are also influencing electoral outcomes. We know that they aren't abiding by a code of ethics because there is no Supreme Court code of ethics. The very minimal recusal kind of requirements that exist that are supposed to apply to the Supreme Court, they don't seem to be following them. CEG Clarence Thomas this week. So I think that we have a body that, if it was operating properly, if it was operating the way that we understood that it would be, if the members of the court were truly separate from these partisan political actors, from these partisan political organizations, we could have a judiciary that had legitimacy that, deserved to be preserved in its current form. I just don't think that's what we have. And I think that the shadow docket decisions are one way that that's manifesting.
Yeah, it's interesting. If we think about the different audiences that the Supreme Court has, on one level, one of the audiences, of course, is just the litigants in the case. At the end of the day, as one of my teachers used to say, guess what? The Supreme Court decides the case of A versus B, and those are the people who are most affected by it. Then there's kind of, I'm going to say, the audience that we have here today. It's the law students, it's the law school people, et cetera, et cetera. But then I think Ms. Coleman is hitting at a different audience, which is a broader public. And again, let's look at it a different way here too, is that the public doesn't separate out the technical decisions from the big blockbusters about gay rights or abortion, et cetera, et cetera. Is the public seeing something that we're not seeing? Is the public looking at the court from a perspective that's very different from ours and saying that, guess what? We see a court that has decided the last 20 years a presidential election. We see a court that is on perhaps the verge of overturning Roe versus Wade, things that affect people on a day-to-day basis. And therefore, their perspective is different than ours. And maybe they are seeing a court that has become broken in their opinion. And so that's an observation there. Sort of, again, if what you think about that. And then eventually what I want us to start thinking about here is it broken? Is it truly broken? And again, I was thinking, I think when Molly brought this up, Ms. Coleman brought it up also, is that this week, Clarence Thomas challenges us in two ways. The role of his wife, and also him essentially, being out of commission, but still participating, in court decisions, it looks like. So again, I throw this out here in terms of saying, is the public seeing something that we're missing, that it is a broken institution now?
So just to offer a thought, I think much of our discussion thus far has actually been about that public perception.
Right.
And of course, it's not the entire public that's focused on the Supreme Court, but I actually think we need to divide it into at least two publics. So I served on President Biden's Supreme Court Commission. And one thing that became very clear to me during that process, if it wasn't already clear to me, is that different people in the public perceive the Supreme Court and what is happening to the Supreme Court and what has happened to the Supreme Court over the past few decades very differently. And so I think people on the left are extremely frustrated by what has happened to the Supreme Court. Many people on the right see what has happened to the Supreme Court as a response to either wrongdoing by the left in the past or simply just the regular political process at work. What that does is it creates a real challenge to say, well, what does the public want? Well, different publics want different things. And I think this suggests, as with many areas, we are a very divided society where people come to the issue of court reform and the Supreme Court's legitimacy from very, very different places.
Okay, good.
It's a really interesting question. I think it suggests maybe some lesson for us, which is that it's very easy for people in the law and law professors for us to get really deep in the legal weeds. And when we look at these cases, there often are, significant legal arguments that people have spent years developing on both sides of every issue. And I think it can be easy for us to just say, well, these are all plausible decisions. There's the good legal arguments, and there's some truth to that. On the other hand, I think it's important to be able to step back and just say, but what's really going on here? How, yes, maybe let's not let our legal training convince us that there's always a different explanation. And I think you need to have those two perspectives in trying to figure out what's really going on at the court.
Okay, good. Ms. Coleman?
Yeah, I generally think that people outside of non-lawyers tend to see things a little bit more clearly than we do. I think that the thinking like a lawyer can get us into trouble sometimes in this profession and stop us from seeing what's really happening. And again, most importantly, seeing how the court is impacting real people. And I think like at the end of the day, if the people impacted by the court think that something is broken, then that weighs very heavily to my mind. I think that there's, and to Professor Grove's point, right? Like there are some people who think that what's happening in the court right now is exactly what should be happening, and of course, when we're talking about outcomes, we're going to get very, very different answers based on if kind of the group that you like is winning in front of this court more often than not. To me, though, that kind of focus on outcomes, despite that kind of being what I think about all the time, that leads us then to this place of making the court more partisan than it should be. And the questions to me that are most salient are, what are the processes? What are the rules in place? Is the system working? Not just are we getting to the right outcomes, but are we having a couple of things here, right? Like, are justices being selected, being considered in a way that fits with the constitutional directives or with our understanding, our norms of how justices should be selected, should be confirmed? There's also like the bigger democracy questions here, right? Which is, what do you do when a majority of the conservative justices on the Supreme Court were nominated by presidents who lost the popular vote, were confirmed by by senators representing a minority of the population. So when you have this, it's not supposed to be the most democratically responsive body. Obviously, I understand that. But when you have a court that is so anti-democratic, that is so out of touch with kind of the general population by design at this point, then of course you're going to get to a point where the court is out of step with public opinion, which is going to lead to more and more people feeling that it is broken, feeling that it isn't working, because if voting only gets you so far in this country at this point, because you have a Supreme Court, again, there as a result largely of minority political rule, it's very, very hard to me to think about how to kind of square that circle without thinking about structural reform. I think I got a little bit off topic from the question there, but that's where that got me.
On topic here. So let's, if the title, I'm looking back at our title here, which is what? The panel, which is all about what? Federal court reform, in the 2020s. And we're basically supposed to be talking about reform of the federal courts. Okay, so So let me throw out another broad question and say that I think at least Ms. Coleman is willing to say it's broke right now. The court, at least the Supreme Court, appears to be broke. Would my two law professors be willing to go that far and say it's broke or not, and why? But then what I'm also looking for here is a sense of, all right, there is what is wrong with the court, and with that, are there things that you would all recommend that we need to start doing to address this legitimacy crisis?
So
there's a lot there, by the way. I know I'm throwing out.
Yeah, let me take a shot at some of it.
Sure.
I don't know if I'd necessarily say broke or not broke. I do agree that there's a very serious problem in that we have this really powerful institution that has the power to overturn democratically elected laws, and its decisions about when to do that seem very hard to disentangle from partisan ideology. And I think that, and that its membership, the way that justices are selected, seems to be based, have a lot to do with chance, who happens to die when. And I think it is increasingly hard to justify this exact set of arrangements. Which part of it should change, which part should go, I'm not totally sure about. I think you can have a different selection system for justices. I think you could try to, create a legal culture that does not so closely track partisan ideology. To the extent that that's possible, you could limit the court's power to engage in judicial review. And I'm not sure whether which of those is clearly the right answer. But I think the current constellation, the current set of arrangements, is a bit hard to justify and coming under increasing strain.
Professor Grove.
So I think it's clear that the judicial appointments process is pretty broken, and in really terrible ways. And one would think that Democrats and Republicans could agree on that, at least. Although I'm sure they would lay the blame in different areas. And this has been happening at the lower courts for a few decades, starting in the 1980s, and gradually made its way up into the Supreme Court nomination and confirmation process as well. So that's clearly broken, and I think has had a huge impact on the public perceptions about the legitimacy of the Supreme Court itself, even though the justices themselves may not be responsible for that broken process. And so to my mind, some of the most important reforms are going to be some of the most difficult, and that is reforms to the Senate process itself. And I'm not sure how that can be done. I'll just say I was personally shocked that the process this week was not a smooth process. Perhaps I should not have been shocked, but I was. And I think that's just another example of a seriously broken process. In terms of Supreme Court reform, that's a huge question. But I think there are some reforms that we should all be able to get behind, including starting with judicial ethics. One would think that it would be pretty easy case to say at least the rules that apply to the entire rest of the federal judiciary should apply to the Supreme Court as well. I'm willing to say that many of the rules that apply to the rest of the government, like rules governing discrimination and harassment, should apply to the federal judiciary as a whole, including the Supreme Court. Just starting with that, I think should be a very easy thing. I will say politically, any reform is hard. I have been surprised to learn over the years that the entity that is most resistant to the reform that I just described has been the judiciary itself.
Good. Ms. Coleman.
Yeah, on the question of if it's broken, I think yes. On the much harder question of what to do about it, I mean, just echoing Professor Grove, like some of this is just so basic. Like I am a huge proponent of court expansion. I think that any meaningful reform is going to have to start with court expansion. I think beyond that, well, there are other sensical, nonpartisan reforms that we could undertake. I think for basic issues of like, will those reforms survive review by the Supreme Court? I think we've got to start with expansion. I also think that there's, the harm that has been done to the court, and I would argue largely by the right over the last decade, we have to ameliorate some of that harm, and that has to start with expansion. That said, I get it. Like that's good. That's not going to be bipartisan, and that is never going to happen. Maybe we can get bipartisan lower court reform. Obviously, there are some bipartisan proposals right now on, or I'm sorry, lower court expansion. But ethics reform, like the Judiciary Accountability Act, which would protect the 30,000 employees of the federal judiciary from harassment and discrimination in the way that virtually every other worker in this country is protected against harassment and discrimination, but not those who work for the judiciary because the judiciary has exempted themselves. I mean, things like that feel like if we can't start there, then we've just, then what are we doing? And I do think that there's good reason to think that some of those reforms could be bipartisan, could be kind of widely accepted across both sides of the aisle. That said, I think that if we're really talking about the harm that is most salient for the most number of people, that's going to be the harm that is caused by what I see as a very broken Supreme Court. And so we're going to have to be talking about reforms that might not be as politically popular, that might not be as bipartisan, but that could ultimately address some of the harm that is currently being caused by the court.
All right. I've got a lot of questions I could ask here, but I want to see if at this point, anybody in the audience would like to raise a question or make an observation or direct something to one of our panelists. And so I want to give an opportunity to make this a little bit engaging here also. And so Dan is saying you can raise your questions in the Q&A box. I don't know if it's possible to unmute also, but I think he's asking basically to put him in the box here. So let's just take a second here and see if anybody's going to pose a question. And hopefully there will be some questions coming in from the audience. While we're waiting, put you all on the spot. And I think a couple of you have done this here. If you could name, I don't know, let's just pick three things. 3 reforms that you would like to see that apply to the federal judiciary or more particularly the Supreme Court. What would your 3 be and why?
I would start with some kind of regularized system of appointments that spreads the appointments out more evenly across presidential terms, that at least makes the membership of the court a little bit more responsive to the results of democratic elections.
Okay.
So I've already named what I think is the most obvious reform, which is judicial ethics, and then adding to that for the Supreme Court, using the same rules we apply to the lower federal courts for the Supreme Court, and then also expanding for the entire federal judiciary protections like Title VII, discrimination in employment.
Okay, good. All right, good. Ms. Coleman?
Like I said, expansion, number one. I think I'll say I'm a latecomer to term limits, was not very sold on term limits until somewhat recently, but I do think to Professor Epps's point, regularized appointments per presidential term, be more responsive to democratic elections. I also just think like getting people off of the Supreme Court has a lot of value. So I am newly sold on term limits and like newly very excited about them. So that would be a number 2. And then an ethics code, absolutely. I'm going to combine that with the Judiciary Accountability Act. So just broader workplace protections and ethics. Those seem to go hand in hand to me. I'm cheating, that's 4, but that's what I would do.
Fair enough. Okay, so we've got 2 questions here. Let me do the first one and again, get reaction from the panelists here. I'll read it. Richard Posner argues that the court's discretionary review is partially responsible for its outsized politicization. Do you think it would be possible, desirable to limit the court's discretionary review?
I guess go ahead, Tara.
Ms. Grove, go ahead. Professor Grove, go ahead first.
Either way is fine. So it's certainly possible. Congress has tremendous control over the Supreme Court's appellate jurisdiction under both its power under the necessary and proper clause of Article 1 and also Article 3, which says that the Supreme Court's appellate jurisdiction is subject to such exceptions and such regulations as the Congress shall make. And Congress has changed the Supreme Court's jurisdiction over the last 2 centuries plus, typically by moving things from the mandatory appellate docket to the discretionary docket, but Congress could move things back from the discretionary docket to the mandatory appellate docket. I actually think there's something to be said for that. The Supreme Court has limited its docket tremendously over the past few decades. So in the 1980s, the Supreme Court decided on average 150 cases per year. And by the way, that's way down from the early 20th century when it was deciding 400 cases per year. It was actually issuing decisions. But certainly one could think they could do 150 or 200 cases per year. I think that in part because of the Supreme Court's concerns about its legitimacy, the Supreme Court will dodge issues that need to be decided. And there's something to be said for expanding the Supreme Court's mandatory appellate jurisdiction. I don't think that would resolve all of the issues we're talking about here. I think there would still be a very large discretionary docket for the Supreme Court. I think the Supreme Court would still dodge certain issues. I think the Supreme Court would still have an emergency docket. So that would not resolve everything, but it might actually help our system to have the Supreme Court deciding more of the less controversial cases and provide guidance to the lower courts.
Yeah, I'd just say it sort of depends on what it would mean for other courts. I mean, if you're taking more cases away from the Supreme Court, some of the lower courts, can sometimes be kind of way more out there, and you might see, more results that people think of as crazy, and that could actually make things worse. So just really, I guess it depends on the specifics for me.
Okay, good. Ms. Coleman?
I feel like this is a good example of why I see the court as ultimately a political actor. I mean, part of this is it's who do you want deciding these cases? I don't really want the Fifth Circuit deciding a lot of these cases. Don't super want the Supreme Court deciding a lot of these cases currently. So, I don't think I have a ton to add beyond that. I don't think I have much to add.
Okay. So some more questions here too. Okay, so another person asks, what do you think the Chief Justice's role is in shoring up the court's legitimacy?
So I think I would say that this seems to be something that a lot of us who watch the court, we think this seems to matter a lot to Chief Justice Roberts, that he seems to be very aware of the court's legitimacy and arguably to make decisions that seem to reflect an interest in maintaining the court's legitimacy. Not everyone thinks that, but there at least is a significant set of folks who think that seems to be explaining some of his behavior. Whether that's good or not, I'm not sure. And you can have different views about that. You can say, of course, it's the Chief Justice's jobs to make sure the court is perceived as a just and fair institution. On the other hand, there's a lot of people who say, no, the Chief Justice should just be justices should just be focused on getting the right answer on the law and nothing else. I think, that can't be right when you're talking about courts' case selection, because they have such unfettered discretion that isn't really controlled by law in terms of case selection, but maybe in terms of the outcomes in specific cases, that may be not a legitimate consideration.
Okay.
Yeah, I think so. So Dan was talking about Chief Justice Roberts actually deciding cases, and some people think that Chief Justice Roberts was trying to moderate his own views and moderate the court's overall jurisprudence in cases like involving the Affordable Care Act and the Deferred Action for Childhood Arrivals program. And I think that's a very difficult question. I think there's a separate question. Does the Chief Justice have an obligation to respond to attacks on the judiciary? And that's not clear. So after President Trump made a comment about Obama judges and Trump judges, Chief Justice Roberts did something that was very uncharacteristic for him. He issued a press statement saying, no, we don't have Trump and Obama justices or Bush and Clinton justices. We have people who are trying to do the right thing and judges who are generally independent in our system. And some people thought he did a good thing, and other people thought he was further politicizing the court by just entering the discussion. So I think it's a very tough question, not just for this Chief Justice, but for any Chief Justice. Should you try to defend your court, or is it better just to stay out of the political arena entirely?
Good.
I'm thinking about this question of kind of which justices on the court are both, by virtue of their role, responsible for preserving or attempting to preserve the court's legitimacy, but also which justices are currently perceived as caring about the court's legitimacy. And Professor Epps spoke about the Chief Justice, and obviously that's who the question was about, but I also am thinking back, I feel like it was at the end of last term, there's a lot of chatter about how Brett Kavanaugh is also one who's very, very concerned about the court's legitimacy, which might have been news to folks who watched his confirmation hearing, but that's a topic for another day. That was something that he was really concerned about. And so that might moderate his votes on some of the more high salient social political questions, because he would want to ensure that the court was perceived as a politically neutral body. And where did that get us? And where does, frankly, Chief Justice Roberts allegedly caring about the court's legitimacy get us? I think that it makes clear to me the structural natures of the court's illegitimacy currently and the brokenness of the court, because no one person can make this court legitimate. John Roberts, by siding with the Democratic appointees on a couple of high-profile cases, if he sides with the Democratic appointees in Dobbs, does that make the court legitimate? No, it doesn't. It makes it a 5-4 decision instead of a 6-3 decision. And that does nothing to fix the structural issues. So while I think that in terms of, to Professor Grove's point, defending the judiciary potentially where appropriate against external attacks or criticisms, that can be an important role. No one person, no two people, no block on the court can compensate for the fact that this is a structurally broken body.
Good. Okay. Another question. We have actually quite a few good questions here. Okay. So somebody else asks, what do you see as the benefits and drawbacks of an expanded Supreme Court where smaller random panels of justices hear cases? And I've heard that proposal being thrown out. I don't know if the rest of you, I've heard this being thrown out quite a bit recently also too. Thoughts about this idea?
So a version of that was one that Ganesh and I, Siddharaman, proposed in an article a few years ago. And I'll say that we thought that might be better with a much larger court because it makes individual appointments less consequential. Now it does create a different set of risks, a risk of kind of randomness, unpredictable outcomes, but it does change at least the stakes of confirmation battles a little bit. But we certainly didn't persuade everyone with.
Okay.
I would just add it raises the stakes, it lowers the stakes of individual confirmations, which I think basically everybody agrees is probably a good thing. It also just changes the litigation strategy, and it changes your ability to tailor a case to who you perceive as the fifth vote on your issue. And I think that is a good thing. I think that making this less about the individual justices and more about who can make the most compelling legal argument is ultimately what we want for our judiciary. And I don't see how you get there with a 9-person court where you know exactly who the median justice is on any given issue. So I think that that's another huge benefit to having random pools, smaller groups of justices deciding.
Okay, good.
Right. I think there are costs and benefits to that system. I think a big question is whether it would be constitutional. So Article 3 does provide for what says the judicial power shall extend to one Supreme Court. And there has been an argument that means the justices must sit together en banc. Now, it does not necessarily mean the justices have to sit together en banc, but when Congress has considered panel systems in the past, which it has, ultimately those proposals have been defeated because members of Congress and a number of justices over the years as well have said that it's unconstitutional. So it's one of those things that I think would be politically challenging, in part because it has that constitutional overlay.
Okay, good. Another question here. given that the judicial appointments process has become a political issue, does it do more harm than good to characterize the court as an apolitical body? This almost kind of brings us back to some of the opening comments we had again here. Let me just read it again, by the way. Given that the judicial appointments process has become a political issue, does it do more harm than good to characterize the court as an apolitical body?
I can start. I think it does. I think that, again, not to harp on the same points over and over again, but I think that there is an incredible problem in this country when the vast majority of people don't pay attention to the third branch of government. And this is true, not just with the Supreme Court, not just with the federal judiciary. We see it playing out in the state courts. We see it around the country, that there is one branch of government that, partially by design, partially by creation, partially by what I would argue is the hoarding of information and access by the legal profession, that the general population doesn't engage with, doesn't think about, and doesn't understand. And that doesn't make for a good, strong democracy, especially when so many of the decisions that are impacting our everyday lives aren't being made by the legislative branch, aren't being made by the executive branch, but are in fact being made by the judiciary. And so to me, being honest about what's happening and being honest about disagreements and different understandings and different ways of looking at the court and thinking about the court, but having that conversation in public, having that conversation in ways that are accessible for people who don't have a law degree, who don't sit around reading law review articles, like that to me is how we get to a point where we can collectively think about what we want our democracy to look like, who we want deciding these major questions for all of us. And so having the conversation, having the disagreements, being honest where we see this as a political body, I think has immense benefit.
Molly, I'm surprised by the suggestion that there are people who don't sit around reading law review articles in their spare time. I thought they were all massive bestsellers. Yeah, I think I will just circle back to what I said earlier, which I think is a version of I'm not sure, which is, does it make it better or worse? Does seeing the court as political, does it cause people to pay more attention and maybe help us build the court we want, or does it just give permission to judges and justices just to kind of treat cases as political? And I don't know.
All right, let me throw out. I'm sorry. Go ahead, Professor Grove.
No. Go ahead and throw out your last question.
Yeah, I was going to say is that we've got a couple other here's I wanted to bring up here. Somebody had put in the chat some reforms that they would suggest. Let me just throw out two of them here that somebody suggested here in terms of reforms. One of them is to say forbid summary affirmances and the like, and then two, consider a junior varsity layer that could review cases of commercial import that would not make the cut under today's limited certiorari rubric. Any reaction to either of those?
Well, I'll just say the junior varsity court. So that has been suggested in the past, and it runs into the same constitutional question that I mentioned before of whether there has to be one Supreme Court that does its work as an en banc whole. In the 1960s and 70s, Congress actually did consider having kind of another level between our current courts of appeals and the Supreme Court, either to help the Supreme Court pick its cases in the certiorari process, or maybe to review some stuff. And people said, no, that would potentially be unconstitutional, or it would be complicated for various reasons. So that's just a thought. I think if we do expand the court's mandatory appellate jurisdiction, possibly forbidding summary affirmances could be a good idea.
Very good.
One thing that I will just add on this, and having given no thought to this junior varsity layer before, so can't really speak to that, but it does, one thing that comes to mind for me is this question of how do we decide what cases are important and what cases matter? And I think that's we've kind of operated under this throughout this conversation as if there are cases, and again, most of the high salience, closer cases that impact people more, that are more important in some ways than sort of the contract disputes or things that feel lower salience that might not make the headlines in the New York Times or even be controversial amongst the justices. I don't think that this would fall into the latter category, but I think about things like forced arbitration and the expansion of the Federal Arbitration Act and things that might seem somewhat low salience kind of in the moment, but over time, as a result of the court's decisions, have an incredible impact. And so thinking about if we were to do anything where we separated out sort of the less important cases, what would that look like? How would we be thinking about that? Who decides what's less important? Who decides what impact those would have? That's one thing that comes to mind. Like I said, having not spent a lot of time thinking about that in the past.
Okay, good. We're out of time now, but I want to give each of you like maybe just, a minute. If you have any sort of closing thoughts that you would like to make as we're drawing the panel to a close. And I do want to thank all the panelists, and I want to thank the audience for some very good and very thoughtful questions. I don't know, Professor Grove, do you have any sort of closing comments?
So all I would say is, as people are thinking about structural reform to the Supreme Court, it's important to consider not only does one want reform right at this moment, but how would you feel about the reform if a political party that you don't support did that very reform? And I think sometimes we forget about the possibilities of our political opponents making reforms that we might feel comfortable having the current political majority make, but less comfortable with a different political majority.
Okay. Professor Epps.
I guess I don't have a ton to add other than what I said, just to return to the theme of, it really raising some really hard questions about whether we should be thinking of the court as political, whether that's productive or unproductive. And I think that's just an open question I want to leave everyone.
Very good. Ms. Coleman.
Yeah, I'll just say that I think that one of the things that I loved the most about law school is getting to spend a lot of time thinking about these questions and discussing and analyzing and reading. One thing that challenged me during law school was it felt like it stops there, and it's often feels so disengaged from the real world implications of what we're talking about, the ability to actually do things. So I'm just going to take this opportunity to a quick plug. If you're interested in thinking about court reform, if you're thinking about how do we make the court more responsive to the democratic will, if you're thinking about any of that, my organization, People's Parity Project, we're asking these questions. We don't have all the answers. We're doing a lot of organizing. We're doing a lot of trying to think differently about all of this. And I think that sometimes it can feel good to get out of the conversation and actually think about how do we move forward? How do we take all of this and actually do something with it? Because these are really important questions and real people are impacted. And I think it's important to go beyond the classroom with a lot of them.
Very good. Good. So I'd like to bring us to a close. I'd like to thank, again, the participants today who are on the panel. And I want to turn this back to, I think, Daniel Suter, or who's ever coordinating the symposium. Do you have any kind of closing marching orders or anything that you would like to do at the end?
This is the conclusion of our symposium for the day, for the entire symposium. Thank you to everyone who attended both this panel and our other panels. It was a pleasure to put this together. I couldn't have done it without, especially the support of the MLR Executive Board. I'll see you all in half an hour at Brits Pub downtown. No, thank you for everything. And if there are no objections, I'm going to end them.
Very good. Thank you. Thank you all very much.